One of the news highlights, I guess, for those in the media, and one that they had to take notice of at the state capture inquiry, is that the chairman of the commission of the inquiry, Deputy Chief Justice Raymond Zondo, lambasted journalists and editors who published sections of the former Bosasa COO Angelo Agrizzi's affidavit before they were presented as evidence before the commission. Well, to talk to us a little bit about that and perhaps whether ethics in journalism have been crossed or lines have been crossed, I'm now joined by adjunct professor at the journalism of journalism at the Wits University, Professor Anton Harber. Thanks very much for joining us. Welcome to the program.
Thank you and good evening.
All right, so Deputy Chief Justice Zondo was angry today. I mean, he really gave it to the media. And you know something is coming when he starts by saying, I respect the media, but do you think a line was crossed by some of the publications and the media that published what was going to be testimony before it was presented?
You know, the rules for media coverage of an inquiry of this sort are set by the chair, Judge Zondo himself. And the rules that he published in the Government Gazette are extraordinarily restrictive. And if you ask me, they're anachronistic. I'm surprised from a judge of the Constitutional Court, because I would seriously question whether such restrictions could withstand Constitutional Court scrutiny. It seems out of step with our Constitution, with the mood of the times, that these hearings should be open. You know, his rule says that without his permission, you cannot publish any document or any part of any document that's submitted to the Commission. Now, if you were to stick to the letter of that law, it means every time you publish something that's in a document for the Commission, you need his personal permission.
But didn't he say that it's okay to publish? He's already given permission. He says you can publish after it's presented in court.
That's not what his rules say. Right. His rules say you have to get his permission. So that's a bit ridiculous. Now he's arguing that what they're doing undermines the Commission. And I think that's a difficult argument to sustain. It's hard to see how it undermines the Commission. This is evidence in an affidavit, whether it's been read out in court here, in the hearing yet or not, seems to me that in fact, you know, there's very many positives to the information coming out. For example, if the witness is in danger, as this witness is, then we usually find that one of the best defenses is to get the information out into the public eye.
What if he wants to correct some of that information in the Commission? So you've got an affidavit and he says, listen, I've had to think about it. I want to use this opportunity, even before we interrogate it, to change the facts. But then you've published already.
Yes, and then you would publish and saying he's changed his version, and that would be the story. It would be quite extraordinary for him at this stage to have something in the affidavit, unless it was a small detail that he made a mistake, but to make any significant changes to what is there as a sworn affidavit. That would then become the story. But you know, the media is absolutely critical to the functioning and the purpose and the outcomes of the Commission. And so I think Judge Zondo actually needs to chill a little bit and appreciate the incredibly important role the media is playing in getting this information out, in getting the public aware, and making the public fully aware of what he's doing in his commission.
He says this is not in the public interest, so you disagree with him that it's published before time?
Well, he's given no argument why it's not in the public interest. In my view, getting the information out as widely and as quickly as possible is in the public interest.
Is there sometimes a motivation, as he might have suggested, that sometimes media houses want to get a scoop and they might be motivated by other things such as money to try and get these stories out?
You know, wake up to the real world. I don't think they get more money. They earn more money by getting it out early. But, you know, a healthy media that's making money is in the public interest. So why he should sneer at the media in that way, I think, is a little uncalled for.
he did warn the media. So we've got the regulations, everybody can read them. Last year, had a similar incident, and he said, I'm warning you, don't do it. Why would the media then literally disobey those regulations and the warning? Is it because they want to get it tested in court?
There's overwhelming public interest in getting this information out as widely as possible. It's extraordinary information. It's completely vital to the future of this country and to the future of politicians and leaders. So I think there's a very strong public interest argument to get it out. I think, as I say, Judge Zondo should relax a little and realize that in the modern world, these things get out, and they should get out, and it has positive effects as well as negative effects.
So I believe Media Monitoring Africa, Mail and Guardian, Daily Maverick are preparing a legal challenge over this issue. And so you're quite confident, do you think, that this might not stand legal muster, the judge's position?
I think it would be very good for it to be challenged. And I think there's a strong challenge. And I think it would be valuable for the Constitutional Court to make a ruling on just how strict such restrictions can and should be. They always lean towards openness. So unless he can produce, which he hasn't yet, unless he can produce a strong argument why the public interest is damaged by the information coming out, then I think the challenge is likely to be sustained.
I'm going to ask you to put on your hat again when you were an editor and you were running a newsroom. Are there ever cases where you might say, you know what, let's not print this, let's wait for it to come out in court or in the commission? Are there ever cases where you might make a decision like that?
Of course there are. You make decisions to hold stuff back all the time in the public interest. But we're in a situation, because our constitution is relatively new, that we're feeling out the territory. And so it's important that there be rulings and clarification as to just what are appropriate rules. I think these rules are out of date. I think they've been copied and pasted from old commissions of inquiry, and it's a very good thing for them to be tested in court.
All right. Prof. Anton Harber, thanks very much indeed for sharing your thoughts with us. And let's see what the courts decide on this one. And they might actually come before Deputy Chief Justice's constitutional bench at some point. Thanks so much for your time.
Thank you.